SwayamPrabha. Digital India. Educated India.
Welcome back to the course of Law of Torts, Consumer Protection and Motor Vehicles. This is the 16th lecture, and we have covered the area of Law of Torts, and we have seen both specific torts as well as the general elements and the remedies that are available. Now, at my very first lecture, I had stated that some areas where torts were earlier applicable have now been also enacted through statute, and they are called statutory torts, and they are treated as part of the discipline of law of torts. Sometimes they are categorized as advanced torts. So, today we will discuss one such area, which is consumer protection, and we will start this journey or discussion on consumer protection from the perspective of a global movement, and from there we will reach to India, and we will discuss the Indian national attempt to protect consumers, and the legislation that deals with consumer protection, the other jurisprudence that has developed, the policies, the institution, and we will do this over 3 lectures, and we will try to within this period have an overview of how consumer protection is applicable or working in this country. In today's lecture, we will discuss these 4 topics: recognition of consumer rights, introduction of the Consumer Protection Act 1986, COPRA is the abbreviation. Then the 1986 Act was repealed and a new Act was enacted in 2019, that is also called Consumer Protection Act. But what changes that Act has enacted, that we will see, and then we will see a very important institution which has been enacted under the Consumer Protection Act of 2019 called the Central Consumer Protection Authority. It is a kind of a new regulatory authority which has come in the sphere of consumer protection, and how this authority works, what are its functions, how and what it is going to add to the dimension of consumer protection in this country. To start with, now everybody in this world is at least one thing that unites them is consumer. We are consume. And consumption can be as nominal as a needle thread to a very huge potential element or product or service. But everybody has a habit of consuming. So in that way, everybody is a consumer. Now initially in the ancient history in both West and in our country, we see that through religious norms, through dictates of kings, through other social norms, this way of the protection of consumer has evolved. But there was no direct statutory mechanism, or there was as such no one comprehensive law dealing with consumers. And with industrialization, the earlier way of looking at consumer matters changed. Now, why it changed? Now, in the early times before industrial revolution, products were very what you call not so complicated, technologically not so complicated, because sophisticated technology was not available. So products could be easily verifiable by consumers. Then the limit of the expansion of production was also not very high. So usually producers were producing that much which has a demand in the market. And finally, there was no large scope for huge amount of export and all, because transportation was not available. Also people could not reach out about their products to a large audience, because modern technologies of communication was not available. So all this made consumers more or less safe, and this gave rise to a principle which we call caveat emptor, that is, consumer be aware or buyer be aware. So it was the initially legal duty that when you are going to purchase a good or a product from the market, you are supposed to do all the necessary inspection of the product. Now, after being satisfied that there is no defect, there is no deficiency in the product, you purchase that product. Now, after coming home, if you find that there is some defect, which may be defect which you have somehow escaped from your eye, then when you go back, the seller is under no legal responsibility to take that product back or refund your money, etc., etc. And this was rule of law by the principle called caveat emptor or buyer be aware. But the industrialization changed this phenomena, because now after industrialization, the nature of the products became very sophisticated and technology based. And with the evolution of further technological innovations, day by day the products that were available in the market becomes very, very complicated. Now, the laptop or cell phone that we are using today, now somebody by physical verification cannot find out anything, because he has to totally depend on whatever the producer is informing him on the package, or whatever the marketing person is providing him information about the product, because he cannot verify. It is such a complicated product. Now, if in this era people say or law say that caveat emptor means buyer be aware, now how are buyer going to be aware? So therefore, this rule had to change, and this rule was over years of advocacy and years of protest by various consumer advocacy groups, slowly saw its demise, and this rule was replaced by what we call a new rule, which is caveat vendor. That means now the sellers be aware. So it became from a seller dominated market to a buyer dominated or consumer dominated market, and that is what we call consumerism, or the rise of the modern concept of consumer protection. Now, in this rise of modern rule or modern law of consumer protection, government had to play a very, very proactive role in controlling the forces of the modern market. Now, the modern market had various tactics and various strategies available before them in order to elude consumers or in order to mislead consumers. But the government had to therefore become more proactive and to take steps for controlling these forces of the modern market. So certain steps were adopted. For example, there are measures which attempt to eliminate abuse of power. Remedies included establishments of codes of conduct. So in private sphere, companies were asked to develop their own code of conduct for business and eliminate the abuse of power or dominance that these players of the market were enjoying in the market due to their position of having a better control over the information or over the market. Secondly, measures were adopted to ensure sufficient information to the consumer to facilitate him the value of comparison in the marketplace. So sufficient information about the products became a norm, and then remedy against unfair illegal advertisement without having unreasonable basis for claim made in advertisement was also introduced. So in order to therefore to safeguard the interest of the consumers in the market, various new remedies started evolving globally, and these remedies included preventive remedies, affirmative disclosure of information requirements, substitution claims, restitution actions, refunds, compensation, corrective advertisements, fines and incarcerations. So a wide variety of both civil and criminal remedies emerged for ensuring consumers are better protected in the consumerist market. However, this was what we call the first phase of the global movement towards consumer. But this was not enough, and there were also discrepancies that were seen in different countries, because different countries were at different level of legal development, different level of economic development, different level of technological development, different level of market practices. So therefore there was a variance, and this variance caused somewhere consumers to be very vulnerable and somewhere consumers to be very safe protected. Now usually in the Western countries, where consumers were more informed, where norms were much more stricter, where this kind of innovative remedies were introduced to new laws, now their consumers were far more protected, and consumers had far more voice. Whereas in countries like India, where the consumer information was less, it was a market dominated by vendors, manufacturers, sellers, and there the consumers were much more vulnerable and much more open to abuse and being cheated. So this led to a very important development, and that development was to first introduce and recognize that consumers have certain rights, and these are fundamental. The first declaration of rights for consumer came in United States by the President John F. Kennedy in his famous historical speech introducing the Consumer Protection Bill in the Senate, where he said that consumers are most important aspect of our economy, yet they are most vulnerable and they have minimum say. So he introduced 4 important rights of consumers. This initiation of United States was taken further, and we see there is a global impetus among other countries also to introduce rights of consumer, because rights of consumer means that now the aspects of various matters is no more just a welfareistic measure of the state or state's duty. It is now the right of consumer, and the state has to create a mechanism to recognize, implement and enforce those rights. And to this extent, the United Nations played a very important role. In 1985, the United Nations came up with its Declaration on Consumer Protection, which is, you can say, the first international document on consumer protection recognizing the rights of consumers and for a better global environment, legal environment or legal framework for protection of consumers. Now to this extent, the UN guidelines required that UN member state to promote in their domestic jurisdiction the following things, and I quote: 1. Ensuring some minimum consumer protection mechanism among the member countries. So some minimum consumer protection mechanism was essential and required to facilitate production distribution patterns responsive to the needs and desires of the consumers. So the production pattern and the distribution pattern should be in such a way that it is responsive to the needs and desires of the consumers. Third, to assist countries in curbing abusive business practices at national and international level that adversely affect consumers. So rules were enacted in the United States facilitated organizations or even private organizations, and then they were in form of model law provided to the countries who can adopt those laws or those norms. UNCITRAL played a important role. OECD played a very important role in this regard. Then to facilitate development of independent consumer groups. Now this is very important. As I said, Kennedy's one of the most important criticism about the system that was prevalent at that time was that consumers, being the most important and essential part of the economy, has no voice. So therefore consumers must be given some voice. Now in a democratic system, we don't mean by the word voice that everybody has a voice. Of course everybody has a free speech right, but when we say voice, it has to be representative voice. So in order to have a representative voice, there is a need to have associations or form groups, and those to be recognized by law and to be given appropriate status and has to be then heard. So right to be organized into consumer groups and the voices of those groups to be heard in appropriate policy and decision making. So to facilitate that, the UN declaration said that development of independent consumer groups. Then to further international cooperation in the field of consumer protection. So consumer protection was most of the time not only matter of national interest, it was a matter of global or transnational interest. So therefore international cooperation was very, very important, and in today's world when we see largely the market is moving from a physical to a online market, this has become even more important. Globalization had made it important, but with the information communication technology revolution and online market evolving as one of the biggest development of the recent time, this international cooperation in the field of consumer protection becomes the key factor. Then to development of market conditions that provide consumers with greater choice. So informed choice is important. Now when you make a choice without adequate information, it is a choice without information. So that is not an informed choice. Informed choice is when you know about what you want to do, you are having sufficient information to come to that decision, and then you are taking the decision, that is called the informed choice. So therefore market conditions should be such that to provide greater choice, and lastly to promote sustainable consumption. So consumption pattern should be such that it is sustainable, and by that time sustainable development has become a part and parcel of the global legal framework. So sustainable consumption was an important aspect that was evolved in the guideline. Further, this declaration or this guideline recognized 7 important rights of the consumer. You can say after the Kennedy Declaration, this was the next important document of international sphere which recognized for the first time the importance of consumer rights and what are some of the consumer rights. So 7 consumer rights were recognized. What are these 7 consumer rights? I have listed A, B, C, D, E, F, G, and I am going to talk about it. The first consumer right which was recognized was access to non-hazardous product, which we also call as right to safety. So consumers have a right to buy products which are not hazardous, okay, which are not spurious, which are not hazardous. So right to safety. So consumers' right to product safety. Okay. Second, promotion and protection of economic interest of the consumers. So whatever is the consumer's economic interest, which is fair competition, appropriate choice making, minimum price control, not a monopolistic market. So protection and promotion through the efforts of consumer protection to ensure the consumers are getting a fair deal in terms of the price that they pay. So value for money. So therefore promotion and protection of economic interest of consumer. Third, access of consumers to adequate information or enable them to make informed choice. So therefore adequate information was an important area. So right to information. So therefore consumers should have a right to information which is to be adequate and effective to make informed choice. D, consumers education. We often see whenever we are going outside in our television a campaign run by the government of India, Jago Grahak Jago. Now what does this mean? This means that people needs to also be informed, educated to become an empowered consumer. Now if you are uninformed, it is very much easy to cheat you. But if you are more informed, if you are more educated about mechanisms of the market, then you are less vulnerable to the market, right? For example, I will give you a very simple illustration. What is the weight of the LPG gas that comes to every household in this country? Now this is a very common information which is lacking. Now if I am correct, approximately I think it is 16 point some kg, which is the gas plus the cylinder weight, and they are usually mentioned at the outside of the cylinder or the bill. So when a delivery boy is bringing the cylinder, it is your right to ask him to weigh before you. They should carry a weigh machine and weigh before you that whether that 16.5 kgs of gas is there or not, because the cylinder weight will be written there and the total weight, and if you deduct the cylinder weight, it will be the weight of the gas. So 16.5 kg, if I am right, it may be 14.5 or 16.5, somewhere between, I am not exactly sure, but it is somewhere between that, and that is what is the weight. So if you are not informed, you will not be able to ask. So this kind of informations make consumers more empowered. So consumer education. So the ministry has made various efforts to introduce education aspect of consumer. So this whole Jago Grahak Jago campaign is towards that. Then next one is freedom to form consumer association. So as I said, the consumer voices to be heard. So the consumer should be organized into association, and this association should be recognized legally, should be given some status, and their voice, the representative voice of that association, should be heard at the time of policy making or decision making with reference to consumer rights or consumer matters or consumer interest. Then access to effective grievance redressal mechanism. This is important. Now, no right is effective unless there is an enforcement. Now, if you have a right without an enforcement, the right becomes meaningless. So, if the Consumer Protection Act or the consumer protection laws are trying to give certain, recognize certain rights for you, then they should also provide an effective dispute redressal mechanism where you can go for seeking the enforcement of your right. Now, in India, the courts are notorious for the problems of delay, cost, procedural complexities, and people are usually scared, and usually the consumer interest or consumer sums are very nominal. Now, for that nominal amount or nominal economic loss, many people will not be encouraged to go to court. So therefore, if you want to effectively protect the consumer rights, then you have to give a special mechanism which will ensure speedy disposal of consumer cases at a less costly, less time consuming and less procedurally complex manner. So that is what is access to effective grievance redressal mechanism. So that was a right which was right to redressal. And the last one is promotion of sustainable consumption patterns. So therefore, government had to adopt policies in order to ensure that the consumer market is available with products which are sustainable, right. For example, all this effort to ban plastic or reusable plastic is to ensure a sustainable production, because plastic generates huge amount of waste which is not good for our weather, for our ecology, for our surrounding environment. It creates much problem. So if you blatantly allow plastic consumption and plastic production, it will all add to the problems of the environment which we are already having. So therefore, we have to use, if we have to discard plastic best, but if we are cannot able to discard because it is so essentially such associated, then in that case we have to use plastic in a very sustainable manner, so that the waste generated from the plastic is not causing a harm, waste can be reused, and the littering of the plastic which causes harm to the ecology is reduced. So that's sustainable consumption. So these 7 rights were recognized by the UN in the declaration. Now this declaration was enacted in 1985. Now we can therefore, in our survey in the past say 20 odd minutes, we saw that how globally a effective consumer protection mechanism advocacy had evolved, and these are all to ensure what is called consumerism. The word consumerism means consumer centric market. So the global movement was to make the market consumer centric, or where consumer becomes the central focus, right, and everybody else plays part with it. So earlier there was a statement called consumer sovereignty or consumer is a king. So actually to make the market, there were claims that the market is such that, especially the liberal market is such that consumer is a king, but many scholars shown through their research that this is actually a myth, because the reality in the market is consumer is not the king, rather the consumer is the most vulnerable. So therefore, this led to the movement towards ensuring better consumer protection, and we saw in the global sphere what developments have happened. Now, the position was not different in India. In the ancient time, I said in India we had also some religious norms and some king's proclamations wherein there was some protection. During British time, we saw IPC and some other legislations evolving, which is trying to protect consumer rights in certain areas, but largely there was no comprehensive legislation. In the post-independence era, we saw a gamut of legislation. Almost 20-25 legislation in bits and pieces tried to protect the consumer interest. But again, the problem was that the implementation of this legislation was very poor. Enforcement was primarily lacking because to enforce the rights guaranteed under this legislation, the consumers had to go to the normal courts, and the normal courts, as I say, is notorious for its backlog, delay and other problems, cost. So therefore, there was no access to justice for consumers, and there was a very large access asymmetry, information asymmetry, because it was a producer dominated market. So producers controlled information. So therefore, these producers, they only chose or select what information to give. So consumers were not informed when they were making their choices. So it was not a asymmetric market, symmetric market, it was more of an asymmetric market bending towards consumers. And lastly, the most important aspect was that there was abrupt inavailability of fair competition. We had various types of markets in India. Indian market is not uniform. We have metropolitan cities where the markets are flooded with foreign goods and all. Then we have rural markets. We have markets which are extremely primarily catering to the most marginalized, economically most marginalized sections of our society. Those markets are flooded with spurious goods, then followed by issues of black marketing and all these aspects. So taking all these cognizance, and also India being a signatory and member of the UN, and therefore incurring the international responsibility to promote consumer friendly laws or consumer protection laws in the country, in 1986 the Consumer Protection Act or COPRA 1 was enacted by the Government of India. Now, Supreme Court of India has, in a judgment of its called Lucknow Development Authority versus M.K. Gupta, had an opportunity to observe what are the important reasons for introducing the Consumer Protection Act of 1986. And let me quote from the Supreme Court judgment, and let me read from the judgment. So, quote from the judgment. So, Supreme Court observes, this Lucknow Development Authority case is a case where the issue was in connection to whether consumers who had purchased or who has booked house properties developed by this Lucknow Development Authority, but there was delay in transfer or there was sufficient deficiencies, whether can file a consumer complaint under the Consumer Protection Act. The Lucknow Development Authority defended, saying that consumers Housing Development Authority are not falling under the Consumer Protection Act. Then it is a public authority, so therefore it is not amenable to the jurisdiction of Consumer Protection Act. So there are several issues. Whether housing development is a service under Consumer Protection Act, because when we in later part of our lecture see the definition of service, we will again revisit this case. So it is a very important case, and it was first path-breaking legislation, path-breaking decisions on implementation or interpretation of the Consumer Protection Act. So before going into those distinct issues which was raised in that case, the Supreme Court of India observed what was the purpose or the reason for the legislature or the Government of India to introduce this law. And as I quote, the malady is becoming so rampant, widespread and deep that the society, instead of bothering, complaining and fighting for it, is accepting it as a part of life. They could hardly afford the luxury of availing the existing dispute resolution system in view of the expense and the dilatory character of the process. Consumers were helpless, faced with powerful business described as network of rackets, or a society in which producers have secured power to rob the rest, and the might of the public bodies which are degenerating into storehouse of inaction, where papers do not move from desk to another as a matter of duty and responsibility, but for extraneous consideration, leaving the common man helpless, bewildered and shocked. So, the language of Supreme Court is very clear that the position of consumer at that point of time, even having so many legislations, even having so many mechanisms, was helpless, bewildered and, to be precise, in a state of shock. So, thus Supreme Court said that to remedy this situation, to overcome and address these challenges, the Consumer Protection Act was introduced, which is a path-breaking legislation. There are other Supreme Court judgments which I have not quoted, where the Supreme Court has observed this is a path-breaking legislation. This is a legislation which is the where welfare was the primary concern. It is a benevolent legislation. So, there were many adjectives that were given in favor of this legislation, but it is a very, very important social economic legislation, one of the social economic legislations of this country. Now, there are some reasons why this is regarded such an important legislation. So, what are the salient features of the Consumer Protection Act of 1986? Because of paucity of time in this course, we are not going into details analysis of provisions by provisions of the Act, but we will give an overview. So, salient features of the Act. The most fundamental importance of this legislation is this legislation for the first time recognized 6 consumer rights. All the laws that were prevalent earlier, they did not recognize the rights of the consumers. This is the first legislation which recognized 6 consumer rights. So, in UN we saw there are 7 consumer rights, in Indian law we saw there are 6 consumer rights. What are these 6 consumer rights? The 6 consumer rights are following. 1. Right to promote and protect the rights of consumer against marketing of goods and services which are hazardous to life and property, similar to the UN, right to product safety. Second, right to be informed about quantity, quality, potency, purity, standard and price of goods or services as the case may be, so as to protect the consumer against unfair trade practice. So, right against unfair trade practice by informing consumers about quality, quantity, potency, purity, standard, prices of goods. So, one example of how this right is enforced. Now, when you purchase gold ornaments today, the most important thing that you do is usually check that whether the manufacturer is using the hallmark standard. So, what is hallmark? Hallmark is a mark by BIS, Bureau of Indian Standard, and the hallmark is a standard which provides that when a hallmark manufacturer is making an ornament, the gold that is using has this amount of purity. So, it is a ascertainment, it is a certainty, and if a manufacturer is using hallmark but not fulfilling the standard, there are penal laws. He can be not only business can be closed down, but he can be sent to jail. So, very few businessmen will take that risk, right. So, therefore, this is a way in which you are promoting or protecting the quality, quantity, potency, purity standard of the products. Third, right to be assured wherever possible access to variety of goods and services at a competitive price. So, now we have legislations like Competition Act, where it says that monopoly is completely barred and other forms of restrictive trade practice we will discuss in subsequent lectures, where and how restrictive trade practices can curb competition in the market. So, competition law is one legislation which tries to protect that, to ensure that prices are in a competitive manner and the market is competitive. Fourth, right to be heard and to be assured that consumer interest will be receiving due consideration at appropriate forum. So, formation of voluntary consumer organizations. So, recognition and formation of voluntary consumer organizations and to allow their voice to be heard. Then right to redressal, and for that we have these special forums which is consumer courts, which have been established only to allow consumers to file complaints and seek redressal of their grievances at a very time effective and less costly manner. And last one is right to consumer education. So, Grahak Jago, right. Now, national consumer policy seeks to provide guidelines to different branches of the government agencies at all levels in maintaining the appropriate consumer dimension while taking any step or decision which will have impact on consumer interest. So, these rights are implemented by policies. So, we have the national consumer policy. So, these are the 6 rights. Of course, the right to sustainable consumption has not been included in the Consumer Protection Act, but it is coming through other mechanisms. So, anyway, expressly only 6 rights have been recognized out of the 7 rights that are part of the UN declaration. Then this act includes pinpoint definition of who is a consumer, goods, services, consumer disputes, which we will discuss in the due course. Then prohibition of unfair business practices. So, complete prohibition of unfair business practices. So, defines what is unfair business practices, what are the types of practices falling under unfair business practices, and then completely prohibits unfair business practices, and anyone who indulges, there are serious consequences through compensation or other remedies that are allowed under the act. Then it creates certain institutions. It creates the institution of Consumer Protection Council from national to state and district level. Then promotion, these councils important function is to promote consumer rights through awareness and education. Then to ensure private, public, cooperation and cooperative sectors to come together and work towards consumer protection. And also this protection councils also functions to ensure consumer participation in decision making. So, in this Consumer Protection Council, whenever a policy decision is taken or a recommendation is to be made, VCOs or consumer advocacy groups are invited and their voices are taken, stakeholder conferences are organized. So, by this way the voice of consumers are heard and consumers get the right to participate in the decision making process. Further, one of the biggest achievement of the 1985 Consumer Protection Act, which is regarded as one of the most innovative global practice at that time, was a special establishment of a special quasi judicial fora at national, state and district level to secure speedy and inexpensive redressal of consumer grievances and violation of consumer rights. Nowhere in the world this kind of a special consumer court was established. Of course, innovative remedies were introduced, some special features were introduced, but in 1986 the Consumer Protection Act of India first time established these innovative special forums called the consumer forums or consumer courts. The purpose was to secure speedy and inexpensive redressal of consumer grievances and violation of consumer rights. We will discuss this in details in our subsequent lecture, the functioning and the description and details of the consumer forums. Then providing a liberal jurisdiction to consumer forums to deal with matters relating to consumer interest. So, consumer forums have a liberal jurisdiction and technicalities are usually asked to be avoided. Then introduce consumer class action. Now, one of the point is that consumer interests are usually very diffused character. So, therefore, to represent those diffuse interests, you may not have sometime a individual consumer coming up. So, for that reason you had to recognize what you call group action or class action litigations, and earlier it was very difficult because there was no such provisions. Of course, PIL was there or representative suits were there in civil procedure, but they were not very effective or they were not very collective avenues. So, this act introduced the provision for class action or class of consumers could bring action against a practice which is affecting the interest of consumer at last. Then provide stringent penalties for violation of consumer rights. So, first time it provided very stringent penalties and then provided measures for compliance and enforcement of the decision of the consumer forums. So, the consumer forums were given the power like a normal criminal court or civil court to enforce its decision, and therefore, if required, provisions like attachment policies etc. were allowed. So, these were some of the salient features of the Consumer Protection Act 1985. But as I said, consumer protection councils were established in the center, state and district for promote protection. So, the important functions that the consumer protection councils were supposed to dispense at different level was promoting consumer rights through awareness and education, then bridge the gap between private, public, cooperative sector and bring them into one forum, then organize stakeholders conference and ensure participation of consumer or consumer voices be heard in the decision making process, recommend new policies. So, these were largely the functions of the consumer policies, Consumer Protection Council, which was an important institution which was operating at the three levels, center, state and district. So, from grassroots to central level there were consumer protection councils established by the Act. Now, as I said that 1985 the Consumer Protection Act was first 86, the Consumer Protection Act 1 was enacted. Then in 2019 that act was repealed by a new act which was called Consumer Protection Act also 2019. Now, why? The first answer to that is that in this almost 34 years of journey of the Consumer Protection Act, it was discovered through empirical evidence that some of the objectives of the Consumer Protection Act was delivered fairly well, but some cases the Consumer Protection Act has severely failed, and in some cases the Consumer Protection Act's performance has been not so satisfactory. So, there were gaps. Now, to address those gaps, since 2012 amendments were tried to be introduced, but in 2017 when one of the amendment was discussed in the Parliamentary Standing Committee, the Parliamentary Standing Committee recommended that why to bring amendments which is changing majority portions of the law, why not to introduce a completely new bill. So, that was why 2019 bill was introduced in 2018 and in 2019 it was enacted by the Parliament as a new law repealing the 1985 Act, 86 Act. Now, what it means that the 2019 Consumer Protection Act does not change or remove the provisions or the good parts of the Consumer Protection Act of 1986. It retains all those characters. Then it adds to the existing law some new features and some innovative new aspects which strengthens or the gaps and challenges that are there due to change of time, due to passage of time, advent of new market strategies, advent of new technological based issues, advent of this online market, globalization, changing of consumer patterns, changing of behavior of Indian consumer. So, the gaps that were arising in the implementation or crisis of 1985 Act was now attempted to be plugged. So, this act was an attempt to plug those gaps and address those challenges. So, what was the good part of 85 Act was retained completely, and the jurisprudence of the good part of the 1985 Act was completely applicable on the 19 Act. In addition, 19 Act had given some new features. So, let us discuss now what are the new features which have been added by the 19 Act. The first is provisions to protect consumer against unfair contract terms, misleading advertisement and deceitful celebrity advertisement. Now, advertisement is one of the most important aspects of modern consumer, modern business practice. Advertisement serves many purposes. One of the most important purpose according to the Supreme Court of India is that advertisement promotes information. Now, because it promotes information, it has been recognized as a part of Article 19(1)(a) free speech. Commercial speech is part of 19(1)(a) after the Tata Press case. in 1991, if I correctly remember, or maybe 94 also, or 93, around that period. But in Tata Press case, for the first time, Supreme Court recognized. Earlier there was denial, but in the first time Supreme Court recognized. So now being part of 19(1)(a) protection, it becomes more challenging to regulate advertisement, because usually 19(1)(a) can be only regulated on the grounds of 19(2). However, advertisement, when it loses its characteristic of true and correct information but become deceitful or misleading information based communication, then there is no bar. So therefore, provisions were enacted by the Consumer Protection Act of 2019 to curb the menace of misleading advertisement, which was regarded as one of the biggest consumer problem and biggest gap of the 1986 Act to properly address. It is not that the Consumer Protection Act of 1985 did not have provisions to curb misleading advertisement, but 1985-86 Act and 19 Act, the important difference was a powerful organizations bringing into life, which is the Central Consumer Protection Council agency, which we will discuss in few minutes, which had a preventive and a regulatory role, and especially in areas relating to unfair trade practices. So that organization became an important watchdog now. So introduction of a watchdog, and the watchdog could therefore perform better in dealing with matters like unfair trade practices. Now unfair contract term was also something which was part of unfair trade practices, but now under the new act it has given a definition, and already there are judgments where Supreme Court has used this provision of the 2019 Act to held contracts, unilateral contracts void because of its unfair terms. Secondly, the new act expanded the scope of many of the existing concepts, such as unfair trade practice, restrictive trade practice, hazardous goods and services, etc. So what was earlier the definition or interpretation, now the new act has extended it. Thirdly, the new act gives a clarity to the concept of who can file a consumer complaint before a consumer forum. Now this became a challenge with the emergence of the online or e-commerce, because when it comes to online or e-commerce, you are not going to a particular physical place. You may be a person from Calcutta, but you are traveling at Delhi and you buy an online product. Now if you say that if you have to go to Calcutta market all the time, Calcutta's court, it is difficult. Then introducing a new chapter on product liability. So product liability law was earlier not part of consumer protection, largely there was some problems, and that was dealt under the law of torts principally. Of course, in our discussion of law of torts, we did not completely went into the discussion of product liability, but in a limited sense in the negligence chapter, the new emergence of the duty of care through Donovan versus Stevenson was the emergence of a new jurisprudence on product liability. Now that 19 Act captures that and becomes part and parcel of the legislation. Some jurisdictional reforms to address the bottlenecks to ensure easier and expeditious access to justice to consumers were introduced. Then of course, the establishment of a new institution, Central Consumer Protection Authority. Earlier under 1985 Act, we saw, 86 Act, we saw two institutions, the Consumer Courts and the the Consumer Protection Council, CPC. But now you have CCPA, Central Consumer Protection Authority. And this is a watchdog, and this is a perfect balancing institution between the CCPC and the consumer protection forums, right? And this is trying to address the challenges faced by consumers in e-commerce, security of transactions, preventing frauds, data security, misleading advertisement, unfair trade practices. So this is a very, very important organization to play an important part in it. Already CCPA has introduced a guideline dealing with e-commerce, and the Consumer Protection Department of Government of India has also introduced model rules based on the 2019 Act on conduct of e-commerce business. So lot of restrictions have come, lot of clarity has come, And with this organization in place now, e-commerce market will be much more regulated than what it was earlier. Then the last is introducing mediation for more speedy and less costly resolution of consumer disputes by amicable way. Now, in the dispute resolution perspective, new changes have been introduced. So litigation is now not the preferred mode, but all around the policy is towards channeling alternative dispute resolution like mediation, conciliation, lok adalat. So in consumer cases also, now consumer forums were itself created as a expeditious mechanism for resolution of dispute, but it was observed that still it failed to perform in true sense a very expeditious, and there were delays also and arrears also in consumer courts. So now to make that address that, a further more speedy mechanism has been introduced in form of consumer mediation. So we will discuss that in our next lecture. So these are some of the important additional features. So as I said, 19 Act does not bar the 85 Act. Don't have this misconception that repealing of 86 Act means the 86 Act is, of course legally it is not valid, but its jurisprudence is very much valid, because 19 Act carries that jurisprudence which was good, effective. It only adds to that part where there was gaps and challenges. Now the last discussion on the Central Consumer Protection Agency. The Central Consumer Protection Agency was established and introduced in the 2019 amendment as a new mechanism. Now the CCPC's function was promoting, recommending and awareness generation. So CCPC did not have Central Consumer Protection Councils or state consumer protection councils or district consumer protection councils. They did not had any role to suo motu accept complaints, investigate, prosecute, but the problems of consumers were such that a organization of similar nature was required. In other countries we see, in US we see Federal Trade Commission which plays similar role. In UK we see Unfair Trade Commission. In other countries like Australia, like Canada, like South Africa, we see similar organizations. But in India there was a gap, and this was highlighted, and that's why, to bridge the gap between the work of CCPC and the consumer courts, and the consumer courts where people who had gone, they would find if there is a violation of consumer rights, then they will enforce it and they will give remedies. But consumer courts could also not suo motu take up matters. So what was required is a organization to balance this gap, and this CCPA is the organization, and that was the objective of its introduction, right. On 23rd July 2020, by notification, the first CCPA was introduced, and it has its headquarters in New Delhi. It is a body corporate, and it has a perpetual succession and a common seal, and has the provisions of the Act and rules, regulations made thereunder hold to dispose property, movable, immovable, etc., contract and can sue or be sued. What are the objectives? The main objectives to protect, enforce rights of the consumer, such as right to be protected against marketing of goods, products, services which are unsafe, to life, property, rights to be informed, then to prevent unfair trade practice, which is a very, very important objective, then to ensure that no advertisement is made of any goods or services which is misleading or deceiving or contravenes the provisions of this Act, then to ensure that no person engages himself in unfair trade practice or takes part in publication of an advertisement which is false or misleading. What are the main functions of this body? The main functions of this body is, first, to conduct investigation either suo motu or a complaint made by a consumer on violation of consumer rights enumerated under the Consumer Protection Act of 1986 or 2019. Conduct search, seizure and to record oral evidence and direct production of documents and records. So almost like powers of an investigating agency or inquiry power. Order on the basis of such investigation recall of goods found to be unsafe or discontinuation of practices found to be unfair or prejudicial to consumer interest. So, it can make orders or directions. Order of withdrawal of advertisement found to be false or misleading. Inquire or cause inquiry or investigation to violations of consumer rights of unfair trade practices. File complaints, so prosecute. File complaints before district commission, state commission, national commission. Intervene in proceedings before district commission, state commission, national commission where matters are with respect to violation of consumer rights or unfair trade practice, and review the matters relating to factors inhibiting enjoyment of consumer rights, including safeguards provided for protection of consumers. So, very wide function. So, it is a watchdog which has perfect regulatory functions, regulators function: investigate, prosecute and decision making. But there is only one question in terms of its formation, that it is largely an executive oriented body. So, whether it is forming a character of an independent regulator or not, but let us not go into that debate here. There are some other functions also, like recommend adoption of international conventions, best practices, international norms for improving the consumer rights in India, undertake promote research in the field of consumer, spread promote awareness, issue safety notices to alert consumers against dangerous hazardous goods, issue notices guidelines to prevent unfair trade practice and protect consumer interest. Already as I mentioned that they have issued a guideline relating to e-commerce and online market. So, that ends my 16th lecture on the global consumer movement to the Indian consumer movement in the era of consumerism. And to sum up, consumerism is the main part and parcel of the modern economic structure globally and in our country. Consumer is a center, and therefore laws, regulations are to be enacted to make consumers more feel protected. Then only the market will work in a perfect manner. So, actually truly make consumer the king. We have sufficient laws now enacted towards that, and in this we have discussed how an evolution of the consumer jurisprudence. In the next lecture I will discuss more in details about the provisions of the Consumer Protection Act in strengthening the consumer protection in this country. And I thank you for being part of this lecture and paying attention. Thank you very much.